Call to order the Regulatory Review Committee meeting for June 8th, 2023. First order of business is a roll call. Dan Ormsby.
Here.
Jim Morrison's here. Mark Eastman is absent. Our business today is draft waste facility licensing ordinance. Anything on it, Dan? Anything that you've seen on there that you don't really care about? I really didn't see anything that I think ought to be changed. It looks like it's all pretty much in order.
Yep. We had a couple things that Mr. Chapman talked about last week that we made some changes about.
I believe those changes have been made. I saw some
Yep.
writing in red in here and stuff.
Yep.
The other item that was asked for was that public safety take a look at the ordinance, which they did. And that's also in here. Formerly, there was a fire suppression system that went from the pump house at the mill through a hydrant system up Route 15, under Route 15 to the top of the landfill where there was a hydrant as well. And that is what provided water when our fire department had to go and respond to calls there when the mill had the landfill, which they did 5 or 6 times a year. They responded to that site. But when AIM dismantled the mill, that entire hydrant system was removed. And so what I put in the ordinance was that any operation would have to restore the hydrant and fire suppression system that was in existence at the time that facility was licensed. That suppression system used the Silver Lake as a water source. It used the pump house at the mill, which drew from that. That's neither here nor there, but the reason I added it is I think that since it was in play when the license was activated for this landfill, that it's not an excessive state law that to ask what was there be restored for its operation. I don't think they could argue that was being stricter than state law because it was already there once.
So we're leaving it, it's their responsibility prior to licensing that fire suppression system be in place, a fire suppression system.
That one, meaning the one with the hydrants that puts a hydrant on the top of that landfill, which is what was there before.
Yes.
Yeah.
It doesn't have to be exactly what they had, but it has to meet the requirements.
It has to have, yes, it has to have a hydrant system that goes up Route 15 to the site.
Mm-hmm. Yep.
Can you describe again what they would have to do in order to put that in? So you said that up Route 15 and what else?
The former system, what was called the pump house.
Yep.
At the mill, that had a series of water lines that went from there to a series. If you go up Route 15, you'll still see some with a cover. Those were hydrants.
Yep.
There's one across from Dead River that still has the hydrant. Some have been removed. But there was a series of hydrants that went out the mill gate, up Route 15. They were spaced. And there was one up as far as the gate, north gate.
Yep.
But there was one a little further down, and then there was one at the top of the landfill, and it went underground to get to the top of that landfill. And according to Deputy Chief Dunning, it provided very high amounts of, a lot of water, plenty of water to be able to fight a fire, because the fire department's concern with a fire at that facility is that the closest hydrant to it right now is down next to what's currently the the credit union. It's down next to the credit union. And you'd have to stage pumpers every 1,000 feet to inline them, and that would not be workable.
Yep.
To the face of that landfill. And so although I know the water source was Silver Lake and that pump house, the source, et cetera, is not my concern. The concern is that the same fire suppression system that was part of its original permitting would need to be in place if it were to be active again, which I think is reasonable because that's what they had before.
Has the state done the work they were gonna do on that section of the Route 15? They were going to, I don't know, resurface it, maybe they were gonna widen it, maybe, I don't know what they were gonna do, but the thing with that is, it would be 5 years after they were finished with that piece of road before that road could be messed with again. So, if this suppression system has to cross that road anywhere, it's 5 years before they can mess with it. Or 4 now, I guess, it's been a year since they did the work.
That's absolutely true, Councillor Morrison. I believe that I don't know if they removed the pipe that they had under Route 15 that took the system over. I know that they removed the hydrants themselves, but I don't know that they excavated that pipe. If
Yeah.
they needed to hook into that, they might be able to do that without disturbing the road surface, in which case they would be able to do such an installation.
Their requirement is to take care of the dump area itself, the dump site itself, with suppression system.
That's correct.
They don't necessarily have to put anything further anywhere else. Now, does the Weber tank still have a suppression system there?
Weber Tank has no hydrant system there. That's something that in looking at this question, that suppression system used to have a hydrant right across from that was active right across from the tank farm, and Public Safety is now looking into what their suppression system is, because at the moment it appears that the suppression system would include that hydrant that's by the credit union that would require staging it. Not as many pumpers as it would to get all the way to the landfill, but it would take a couple. So they're looking into what their suppression system is to see if it was being served by the mill system as well. They were not notified that it had been changed.
Is it, well, at this point, we have left it to the people who want to open the dump or get their license for opening the landfill. It's up to them to take care of any logistics that have to take place as far as getting water in there. So we know that that's gonna get taken place before we, so it's really a non-issue with us right now. It's all taken care of. Any other questions as far as it goes? Edmund, all it says in here is that there will be alternatives for clean water. Because it says they're gonna be monitoring wells other than the regular monitoring wells. It's gonna be ones outside of the area. And it says that replacement water, or, I don't know, for some reason I can't seem to keep the right glasses on here. I'm having trouble.
It doesn't specify what kind of, whether it's bottled water or whether it's hooking into a public water supply. Is that what you're?
It says here, plans shall be made for an alternate water supply to replace private wells which could be affected by the solid waste disposal facility. Now, we had a gentleman come up here and said he didn't think the idea of handing out plastic water bottles to people was gonna be the answer, that they ought to have. Have we discussed with them any idea what they're gonna do, or do we even know who to discuss this with?
At the time, the owner of the landfill would have made an application, that part of the application would have to indicate what the source of the water, what the, if someone said, if a well gets contaminated, we're gonna just give people bottled water, that wouldn't be a reasonable alternative for people who were running a home. So they would be required to tie into public water would be the only alternative for that, or some sort of filtration system put on somebody's well, which are other things that have been done. But that comes through the application and review process. what is, reasonable, I guess, in terms of, alternative, but if they contaminate a water supply that is somebody's well, then bottled water won't cure that for the operation of a household.
The way I understand it is after they applied for the permit, that would be the time for requests, negotiations that we can't specify in an ordinance.
Right.
Correct.
It says they have to do water, that the application and review process would determine if what they were proposing was acceptable to the town.
Trying to find 8.2 here.
Insurance, Jim?
Yes, it's set up there where I was just reading those lines to you that it said go to 8.2 or something, so I'm at 8.2 and it says liability insurance. I guess they figure that coverage must be provided for bodily injury and property damage and must be provided for the active life and closure of the solid waste disposal facility. I guess they figure that if your water gets contaminated, that's property damage, and liability insurance should be there to cover it. I guess that's just to protect all concerned. I'm gonna put a big piece of tape on one of these so I can tell it from the other one. No, that's better. Now I can see. Yeah, it looks like they're gonna be covered by insurance, but it still leaves them with the opening to put any kind of water source they wanna put in there and call it good enough. It's gonna have to be on an individual basis, I would think. If somebody's water gets contaminated and they don't want plastic bottles doled out to them, they'll have to tell them to find something different. It never happened, but as far as I can say. I guess we've learned that don't matter what the laws say anyway.
So does this need a motion to go forward to?
I had not put it on for a first reading tonight. I did that the first time and then it didn't go anywhere, so I thought I'd wait to see if the committee was satisfied that this was ready to go for a first hearing, and if it is, I will put it on the June 24th meeting if the committee recommends that it move forward.
Yes, so doesn't need a motion to go on to the next meeting?
It's just gonna need a recommendation from
Yeah.
the committee
Yeah, it's a recommendation from the committee.
to go forward for a first reading at our June 26th
Yeah.
meeting, whatever it is.
So I recommend this goes forward to that.
I'll second it. All in favor?
Hang on, Jim, I
Excuse
think
me?
you got something wants to.
Does the
I'm
public get
sorry.
an opportunity to voice their opinion
Yep,
on?
step right up, sir. Yes, go ahead.
There are other people here too. I was just a matter of procedure, Councilor Morrison. I was just hoping that the public is still recognized in this process. Thank you.
Yep.
Good evening. Thank you for taking public comments. My name's Ralph Chapman. I live here in Bucksport on School Street. I won't take as much time this time as I did the last time. I appreciate the attempt at a variety of corrections of things that I brought up last time. there are some things that could not be corrected in the sense that you're bumping up against the restrictions of the state not allowing the municipality to have something more stringent than the state rules, and I understand that blockade. And last time I mentioned that I think it would be helpful for the town to communicate their frustration with that impediment to the town serving its own interest, and that communication, I think, rightfully goes to the legislature since it's a matter of statute. It obviously wouldn't be taken up at the moment in the legislature, but I do think that it's important to pursue remedies in favor of the town when you recognize a barrier that the legislature has caused the town. I want to make a very quick point about one of the corrections that was made, just so that we understand what it does or doesn't do. I'm on page 38 in section 9.1. This was to be sure that the town would be able to sample monitoring wells, and the correction here is to say that it would be able to request sampling of on-site monitoring wells as well as wells that would be around the property of the landfill owner. I just want to point out that putting in the ordinance that you're able to request the sampling doesn't actually give you the right to sample. There may be a good reason of not putting in here the ability to do the sampling and only to request to do the sampling, but I wanted to bring that out, that the request could be denied and then you wouldn't do the sampling. The other matter which is missing, and I suspect it's missing because of the barrier that we just spoke of, is the financing for the enforcement. I don't know if I mentioned it last time, but the Department of Environmental Protection as a state agency is legally represented by the Attorney General's office, which is sometimes called the largest law firm in the state. Now, it's not a law firm, but it employs more lawyers than the largest law firm, and so colloquially sometimes the Attorney General's office is referred to as the largest law firm. And I mentioned last time that the department, to my hearing, has been arguing its lack of resources in order to do various tasks that we as the public might think the department ought to be doing, whether it's monitoring or enforcement. And I did mention last time that if the department is not able to do the enforcement due to a lack of resources, why would the town think that it has the resources to do the enforcement? Now, what I'm imagining, and I'm imagining a situation in which the town tries to do an enforcement action and it gets what I'll call tied up in the legalities. By the way, I'm not a lawyer, so nothing I say has legal significance here, but I'm reminded that the Orrington chlor-alkali plant lawsuits carried on for more than 2 decades before a court decision came that identified a responsible party for doing some remediation work. A couple decades of legal costs on the part of the town working against a company that has far more resources than the town is what concerns me. And I can understand that putting an enforcement financing mechanism in here could be considered a further impediment to licensing than the state allows. But in the same way of asking for the cells of the landfill to be lined because of the particular, not necessarily peculiar, but the particular circumstances of the town's public water supply nearby or the river nearby, which is different from the state as a whole. It was an argument for why it was okay to ask for lining of the of every cell in the landfill. And it seems to me that the same logic applies to the town does not have the resources of the Attorney General's office to work on enforcement issues. And so particular to the town, a financing mechanism would seem to me to be an appropriate thing to have. There is a financing mechanism here for an applicant for a license to be paying the costs of the application review. And I thought that a similar financing mechanism could be used to pay for the enforcement. As I say, there may be a reason why I don't see it here, but I think that's still a matter of concern. And then finally, we're certainly better off with the ordinance than without it, because it assures the town of getting the paperwork, and it gives the town the legal authority to do enforcement, whether the town has the resources to do so or not. And that's an improvement. At the same time, the fundamental issues, I think, have been so severely constrained by that state statute involving not doing things beyond what the state can do in terms of the regulations, that I would recommend that we think a little bit longer term in the future of other ordinance mechanisms for helping to protect the town and protect the town's water in particular. So what I'm imagining there is what I'll call water protection ordinances that could deal not only with landfill matters, but a whole host of other water-related matters. There are towns in the state that have enacted various types of water ordinances, and it's premature to do that right at the moment, in my opinion, because clearly the townspeople as a whole need to be educated and aware of what the problems are and what an ordinance could do to help solve that. But I'm recommending that is another layer of help that the town can provide for its citizenry, and it might overlap in a way that helps us with this issue that this ordinance can only put a slight stopgap to. So those are my comments. I appreciate the effort that the town manager and all of the councilors have put into this issue, and being responsive as best you can to the concerns of the citizenry, and I appreciate that. Thank you.
Thank you.
So, couldn't we, this would be more of a council thing, but schedule an invite for Ron Russell's to express our concerns with him, for him to take that ball rolling in Augusta?
We can do that. The reason that it isn't this way, the reason this is one of the pieces of legislation that doesn't allow a community to be more strict than state statute is that solid waste and waste disposal is a responsible state, it's a responsibility that every community in the state has to dispose of or make arrangements for disposal of waste within their community, and that the idea that you can have 17 different conditions for a facility in 17 different areas of the state wasn't at the time they redid this all in the 1980s and created the hierarchy seen as a way that would provide a good result. Because if every community could just say no, every community would just say no, and then there would be no facilities anywhere.
No, I don't mean about us making our rules more stringent. I mean
And-
about the state level of like saying bottled water is absolutely.
Well, I don't
an
think that, bottled water, in my experience, was provided to people whose wells did not test poorly, but they were within visual sight of the landfill, and that created an anxiety level. We tested their wells. Those that didn't were hooked into public water. But otherwise, it was, I know Juniper Ridges is separate from my experience and what happened, but bottled water was only for drinking for people, but their wells weren't contaminated. Their tests of their wells were not contaminated, but the visual of a landfill that's from here to there created an anxiety that they got bottled water, and still do, even though that facility's closed and they're still doing the well testing. But what I was talking about was the stricter than state law kind of thing. That's the piece that is tied to creating a situation in which everybody could say no, everybody would say no.
Right.
And then there would be no facilities anywhere of any kind, because everybody would say no. And that's the difficulty. And to address just for a second, the idea, we're not going to be able to include a standard in this that says that they're gonna fund our legal costs if we don't permit them, or if we don't, if it's an enforcement action, there can be a fund, and that's generally negotiated through a host community benefit agreement, that there is money there to do testing, evaluation, the things that would put additional costs on a community can be negotiated into a host community benefit agreement, which every facility has to have if it's a public facility. And so that is where some of that kind of, how often do we evaluate things kind of money goes. But if it's a push come to shove legal cost thing, I'm not sure that, no, I am sure that we're not going to, it's not going to pass a state review that we ask a licensee to set up a fund so that we can sue them, or that we can litigate with them, or that we can have those kind of costs. That's not gonna be seen as something I think that DEP is going to, I've tried really hard with language to tie a lot of things that I've asked for that could be seen as stricter than state law to pre-existing things, to things they did before, so that it can't be said that it might be stricter than state law, but it doesn't matter because they already did it. And if they already did it, then it's reasonable to think that they have to do it again. But some of the, I would be very hesitant to try and fund somewhere other than through the host community benefit agreement that identifies money that they have to set aside for. I mean, there was a set aside in the Hamden thing of almost $3 million that was in the event that water was contaminated, and it was an environmental trust set up that the town could access if there was some negative impact that the town had to act before the state guarantees kicked in for their bonding. And that fund still exists. They're still using that in the 30 years post-closure in that community. So something like that's a possibility, that there be an environmental trust set up if they were to seek reopening this for some other purpose than its original intended purpose. That would be possible. It wouldn't be able to fund legal fees, but it would fund environmental issues that arose from its operation. So.
Are there any further comments or questions from the?
Just a very quick question, check up here.
Yes, please.
We're down dealing with all the nuts and bolts of maintaining and remediating the site that's here right now. But just really a question, getting back to the big picture, it seems as though there are two issues. There's the control and remediation of the site, and there's the question of, is it ever gonna be reopened for waste all around the state? I'd like to know, do we know where AIM is at now and what they're really hoping? Are they still hoping to reopen it? And then who is right now controlling the site? I mean, we're talking about efforts being made right now to have water up there, fire suppression, whatever. Who is paying for that right now?
No, nobody is.
Nobody.
The fire, the ordinance didn't contain any language that had been reviewed by public safety. And so public safety was asked what they felt was necessary in order to be able to deal with it if it ever was again. And public safety said they would need to have the same system they had in place prior to, which is this very large fire suppression system. Nobody's doing it. I have had no contact with AIM. I have checked with the DEP on a weekly basis to see if AIM has reached out to them or anyone has on their behalf or anything to do with this landfill, and the answer has been no. So that's what I know about what they're doing right now. And this is all preparatory to the fact that that still sits there and it's licensed space. So if anyone were to think about doing anything with it, it would have a process at the local level that it would have to satisfy in addition to the state process.
We can't just say no.
Right.
I mean, I know that's what everybody like to say, and I hope people appreciate that the council, whoever is sitting on the council, whatever time something like this comes, is going to do the right thing for the town. We just have set this up as a safeguard, because we didn't have anything before.
Yeah.
So this is set up, and a lot of this is out of our hands. It is truly state law and state rule.
Right.
That, I'd love to see the efforts here go to Augusta. If we truly want to get things changed, that's where it needs to start. We're trying to do our best to meet the requirements that have been deemed on us by the state to what limited piece we can. But I truly hope that people understand that as a council, we are going to look out for what is the best interest of the town when these things come across. And,
I think I pick up on a great deal of appreciation for what you guys are doing out there, realizing that we went from ground zero to you guys doing a really good job to pull this ordinance in and try to figure out all the
and I think
loose
that
ends
will
going
continue
on.
for as long as any of these processes. I think we can go only so far and do what we can, and then I think again I don't have a doubt. We don't have an application in front of us. We have nothing to act on. I can't give you an answer and say I'm never going to allow company ABC to do that, because I don't even know who ABC is.
Yeah. No, I was just concerned about what's happening in the meantime. We've got a
dead site.
disaster out there, and who's responsible for it? I mean, what if it goes up in flames tomorrow? I mean, who's going to deal with that?
That's what the DEP, the state is responsible for it. We let them know. They know about it.
Okay. And we'll look forward to the future too. I think Ralph has brought up some good issues about, approaching the legislature for, more autonomy for the town so that we can actually have more responsibility for our own town. And we'll count on you guys to do that. Great. Thank you.
And we count on you to do that also.
Any further comments or questions?
Yep.
Please.
My name's Katrina Bisheimer. I obviously live in Bucksport, and I wanted to thank you all for all the work that you put into the ordinance. It's pretty clear that you took our suggestions and our input, and with your expertise and drafted this. But having said that, the one thing that really kind of, as I was thinking about this meeting, that I had concerns about, let's say the current owner decides I'm just gonna sit here for the next 2 years and I'm gonna do nothing. So they don't sell, they don't communicate, and that landfill sits there in the condition that it's in. That was my concern. And I just heard you guys say that the DEP would be responsible for holding them accountable, but so far, they really haven't been able to do that to a large extent. So that was one of my concerns that had come up. And I had a thought as I listened to Susan speak earlier that I know I read through the home rule, I read through Title 38 to kind of get an understanding. My husband's a lawyer, so I get it, and I get what you were saying about everybody would say no because nobody wants a trash dump in their backyard. That's true. But having said that, it is also true that Bucksport is very unique and has particular geology, if you will, with the river there, with our drinking water. And one could argue that you should consider those or the state should be able to consider those because it's different. And so hopefully, you know, demanding standards like liners that's the standard now. You know, Bucksport, this isn't the standard. This was the standard when it was made. And so, anyhow, I hope that they do accept that in the ordinance. I feel like things like that are really important. And my last thing was that, again, this would go in terms of going to Augusta, but I feel like sometimes laws aren't always just, like we make laws to regulate things, but they are not always just, you know, like being able to dump untreated or sort of semi-treated leachate into the Penobscot is not a just law, and we know that now. So we have to try and change laws and that aren't just or don't protect the environment or don't protect people or towns. So I guess that's about all I have to say. But most of all, I'm grateful that you guys are doing your work and listening. Thank you.
I would note that if this ordinance had been in effect at the time that the landfill changed hands and things were being discussed that talked about doing away with secondary treatment and those kind of things, we would have known that. And we didn't. So if nothing else, understanding what's being asked for and being able to, I think we could have made a cogent argument that that was not the right thing, that the secondary treatment needed to stay in place. But we didn't know, so we didn't know. So that's where we ended up with that. If nothing else, an ordinance such as this, you're not chasing it, you know before it happens. At least you have it's a current event, not a past event that you're trying to make up for. So.
You can set argument before it happens.
If you're part of the review process, you're part of the review process. It's not done until everybody's done. And there's something in law that says that if a landfill is idle for a certain period of time, that there can be something about closure. Because I talked to a person at the DEP about that as well. Because it has been functionally pretty much idle since 2014. The amount of tonnage they took in during demolitions was minuscule compared to the capacity of that. So, and there's been nothing since then. So that's always another avenue, because I know that exists in statute, that there's something but a certain number of years, so.
Don,
I'll be quick, Counselor Morrison.
take your time.
Thank you. Just two quick things. I want to thank this committee. I want to thank the council as a whole, and I want to thank the town manager for listening and taking our concerns seriously and adopting them. I hope we've been helpful. The one question I would have, and I think this ordinance protects us as best it can, minus a couple of comments that my colleague, Mr. Chapman, said, is on 6.2, section 6.2, just a very simple wording. The council may elect to have a hearing on an application for an original license for an existing facility. I think it would be a simple thing to, the council will elect to have a hearing. It's on 6.2 on section procedures. I think that would just give certainly an opportunity to bring that to public attention and input from people that may be interested, as you see that there is considerable citizen interest in this. So thank you. I just wanted to say thanks very much for all your efforts.
Anyone else? You all set? Okay, we have a motion and a second. Let the vote. In favor? Passes.
I'd like to say, Sue, I really the work that you put into this on top of everything else is incredible. So I really appreciate that. It's a lot of work to do something like that.
Thank you.
Lots of hours. Motion to adjourn.
Second. All in favor? Motion.